ago. So without further ado, I will hand over to Christian. Thank you so much.
Thank you, Emma. Thank you, everybody, for attending this morning, the Inquest and Inquiries talk in the COVID-19 era. We are delighted that the Senior Coroner for South Wales Central is going to begin the session with a segment on the Chief Coroner's guidance on COVID-19, and in particular, advice sheet number 37. And so it requires no further introduction. Senior Coroner for South Wales Central, Mr. Graham Hughes. Thank you. So you need to unmute your microphone.
And restart, Mr. Howells. Thank you very much. Good morning, everyone. First of all, my thanks to both Legal News and to 30 Park Place for inviting me to open this event. It's my first ever webinar, either as a presenter or as an attender or attendee. So if my etiquette is perhaps not up to scratch as what you're used to, then please forgive that. I was given earlier by Mr. Howells a list of the attendees today, and there are some names on there that I haven't heard for some time. So to those from my legal past, good morning to you in particular. It's nice to not see you, but to know that you're still alive, which is always good from a coroner's perspective. A caveat, first of all, and to some extent a disclaimer. What I'm about to present on, and I really should put a timer on because I probably get run away with what I'm talking about, represents my views, and they are not necessarily the views and approaches that will be taken by other coroners around Wales and around the country. That, I know, at times can frustrate practitioners. That there's a perception perhaps as coroners we all do things differently, sometimes slightly differently, and sometimes significantly differently. Why is that? And that's in part because the legislation and the Coroners and Justice Act 2009 and enforced and repeated in the Chief Coroner Guidance Law Sheet 5 reminds us all that coroners have a very wide discretion. And wherever there is a wide discretion, there are bound to be variances of approach. So, conscious of the fact that I've only got a relatively short period of time to discuss my topic with you, I'll go straight into that. And what I'd like to do is to go to take a step-by-step approach to the question that I posed, which was this. COVID-19 and industrial disease, question mark. So that's the question that I've posed. So this is a step-by-step guide or an approach as to how a coroner's, or certainly myself as a coroner, would approach the investigation, the preliminary investigation of the death of a worker or death at the workplace or following exposure at the workplace of an individual. And so the first question, or the first step, is this really: how is it most likely that the death of a person at work from COVID-19 comes to the attention of the coroner? And by and large, that's likely to come from a medical practitioner. Medical practitioners have a duty under Regulation 3(1)(a)(9) of the Notification of Death Regulations 2019 to refer a death to the coroner if that doctor suspects, so that's a low threshold, that the person's death was due to an injury or disease attributable to any employment held by the person during the person's lifetime. And if they have that suspicion, they must refer. So it's mandatory that they refer that death to the coroner. There's some guidance on those regulations, which was issued by the Ministry of Justice in September of last year. That's available on the web. And at paragraph 22, the guidance says this: in relation to workplace related deaths, it says this includes deaths that may be, again a low threshold, due to diseases received in the course of employment. So that's quite a wide definition for doctors to rely upon when they refer deaths to the coroner. So once the death is referred to the coroner, what's the coroner's duty? And that's enshrined, as you probably all know, in Section 1 of the Coroners and Justice Act 2009, which says this: a coroner must conduct an investigation if he or she has reason to suspect that a person's death is unnatural. Now, you will all know there are there's other criteria for referral, but for the purposes of today, we're looking at deaths that are unnatural or reason to suspect are unnatural. And in the recent Chief Coroner Guidance 37, there was a reminder to all of us about what reason to suspect means. And in paragraph 11, it emphasises that that is a low threshold. The coroner only needs grounds to surmise. So at that stage, when the referral comes into the coroner's not assessing the evidence to the standard of balance of probabilities, but grounds to surmise that that death may be unnatural. What does the coroner then do to decide or determine if that duty is engaged? And that's step 3. So the coroner carries out pre-investigation or preliminary inquiries under Section 1.7 of the Act. And in such deaths that have been referred to me recently, I've had my officers carry out very extensive preliminary inquiries. Normally, preliminary inquiries are relatively brief, but in the cases that have been referred to me, they've been quite extensive inquiries. And what types of things is a coroner looking for in that referral? And I think the most important thing, first of all, is what is the evidence in support of the medical cause of death? So the doctor has proposed in the referral that the individual has died of COVID-19. What I need to know is that confirmed COVID? Is that suspected COVID? What tests were undertaken in hospital? CT scans, X-rays, swabbing? Do I need a post-mortem examination to determine the cause of death? So that's very important, because as we'll go on to look at, I have to be satisfied that the disease caused the death. So causation is very important. So that's really the first thing that I look at. And the other questions that my officers will ask, they will look at the nature of the employment, they will look at what the alleged exposure to COVID at work was, looking for a clear timeline of events. When was there an onset of symptoms? Look at the family situation. Was the individual possibly exposed to COVID at home or from another source? And then I'll look at what steps the employer had taken to address the risks of exposure. What type of personal protective equipment was provided? When was it provided? And a crucial element for me at this time was we're dealing with quite a novel pandemic, a novel situation. Has the death been notified by the employer to the health and safety executive under the RIDDLE regulations? And that's emphasised in the Chief Coroner's Guidance 37 at paragraph 5. That notification is an important factor for me in determining whether I have the statutory duty to investigate. What does the employer think? Has the employer referred? And all of that builds a snapshot of the information or evidence that is available not long after the referral, not long after the person has died. And it's on that information that the coroner makes a decision to investigate or not. So making that decision is the next step. And it seems to me that where we are at the moment is potentially having two types of scenario. And the first type of scenario is the one that's dealt with very much in the Chief Coroner's Guidance 37, and that's at paragraphs 11 and 12. And that looks at whether COVID-19 in the workplace is potentially unnatural if there is reason to suspect that there is some human failure contributing to death. So and that in the workplace, it goes on to say, may well be in the form of an employer failing to take precautions which caused the deceased to contract the virus. And that's the situation that many of you will be familiar with, the touche, unnatural type of situation. That's what the guidance very much focuses on, and there will be those types of cases. But that is a whole complex topic in itself, and that's not necessarily in the time that I had available to present today what I wanted to emphasize or what I wanted to dwell on. There will be cases such as that, and it may well be other speakers will touch upon that in their presentations. But what I wanted to focus on was a second scenario, and perhaps a simpler scenario. And the question is, I believe, does the duty to investigate arise because the death of an individual is considered unnaturally due to it being an industrial disease? Now, traditionally, we look at industrial diseases as coroners and lawyers as asbestosis, mesothelioma, pneumoconiosis, silicosis, the traditional, if I can put it that way, types of industrial disease that are regularly inquested in this court and around the country. But there is no statutory definition of what constitutes an industrial disease for the purposes of an inquest. There's some help in Jervis in the 14th edition at 1344, and that offers this definition, that an industrial disease is any disease caused by employment. And Jarvis then comments, and it's crucial in my view, that if in that situation the coroner is satisfied that the disease was caused by employment, the death then is, or reason to suspect at least, that it is unnatural. The other textbook we all look at is Dorries, and Dorries in the 3rd edition goes perhaps slightly wider than Jervis does and gives a definition, a test for industrial disease as follows. First of all, it's a 2-limb test. Firstly, the disease was due to, which is arguably, I would say, wider than caused the death, which Jervis says, by an exposure at work. And secondly, the disease caused the death. And that test, we're told, is, of course, as we know, on a balance of probability. So if there's sufficient evidence for both of those elements to be met, then the conclusion will follow as one of industrial disease. But of course, that's for the purposes of an inquest. And I go back to what I discussed earlier, that at the time that I'm talking about today, the coroner only has to have reason to suspect on the evidence that he or she has, and then that duty to investigate arises. So, is there some assistance as to whether COVID-19 falls into the category of an industrial disease? And there is. And if one looks at the Social Security regulations, and in particular the Industrial Injuries Disablement Benefit regulations, many of you will know that they prescribe diseases. And those prescribed diseases for the purposes of compensation payments can be found at Appendix 1. And it's interesting and important in my view that one of the prescribed diseases within the Appendix 1 is B5. And B5 refers to tuberculosis, or a tuberculosis infection, as being a prescribed disease. And it goes a little further by specifying the types of job that apply in the relation to that prescribed disease. And it talks about those individuals having contact with the source of tuberculosis infection. And it gives examples such as doctors, nurses, ambulance crews, pathology technicians, and social workers. And so it seems to me that that guidance in the regulations is helpful in at least placing a biological agent such as COVID-19 within the category of prescribed diseases. And so it seems to me that in answering the question COVID-19, an industrial disease, that in my own view, it is potentially an industrial disease. And if the circumstances of that referral are sufficient to give reason to suspect that, then there will be an inquest. And so that's a bit of a machine gun resume of my own views in relation to COVID-19 in the workplace. It's an evolving situation. What I'm not going to do today, I think I'm close to probably my time limit now, is to go into what the scope of those inquests will be. That at the moment, I think is a situation which we will all, as coroners, keep under review. Those inquests that I have opened, where there is a workplace element, I'll probably have a pre-inquest review. And those pre-inquest reviews will probably take place next year. And we'll have a clearer indication, perhaps, from a national level, whether there's going to be a public inquiry in relation to COVID-19. And if there is a public inquiry into COVID-19, then it may well be that some of the inquests that I will have opened will be suspended or adjourned pending those inquiries. But at the moment, there isn't a public inquiry, and so those inquests will continue. Scope will be a matter, as I said, for consideration with the interested persons when those matters resume in the new year. So I hope that will spark some debate. It isn't it is my own view. It's the view of a number of coroners, not all coroners. So we will see how the law and practice develops over the next few months. And thank you for letting me present to you today, and good luck.
So thank you very much for taking the time to provide that informative talk. It won't surprise you to know that I'm going to address the issue of scope of these inquests, and I've set myself a rather wide task. So I'm going to get down into the detail straight away. Firstly, I'd like to start with some basics in relation to Article 2 of the European Convention of Human Rights. Article 2 provides, insofar as is relevant, everyone's right to life shall be protected by law, and no one shall be deprived of his life intentionally, save in the execution of a sentence of a court following the conviction of a crime for which this penalty is provided by law. The positive duty under Article 2 is formed of two substantive duties. Firstly, the general duty, and secondly, the operational duty. The classic formulation of the general duty is contained in the 2009 House of Lords decision in Savage and South Essex NHS Trust, where the House of Lords stated that there's a duty upon public authorities to employ competent staff and ensure that they are trained to a high professional standard. In addition, the authorities must ensure that the hospitals adopt systems of work which will protect the lives of patients. And it's that part, the systems of work, that I'm going to spend some time focusing upon. There also has to be a sufficient relationship of proximity between the state and the deceased so as to engage the general duty, and that's based upon the vulnerability of the deceased and the assumption of responsibility by the state. Prisoners and mental health patients are classic examples where the duty is engaged. The duty in respect of systems is to put a reasonable and proportionate system in place to reduce the risk of loss of life. It is not an impossible or disproportionate burden, and for that, see the case of Longman, Secretary of State for Defence, in 2015 in the Court of Appeal. Individual errors must not be equated with failures of systems. It is the latter that is required to establish a breach of the duty. Mere negligence is not enough. In the context of healthcare provision, the general duty is modified. There has to be a failure to provide emergency life-saving treatment in breach of professional obligations resulting from dysfunction in the hospital services, and this will be a structural issue linked to the deficiencies in the regulatory framework. So that is a rather different test to the test in Savage, and for that see the High Court decision, Divisional Court in Parkinson and the Kent Senior Coroner. Apart from the general duty, the systemic duty, there's also a freestanding operational duty to take all reasonable steps to prevent life where it is known or ought to be known that there is a real and immediate risk to life. And for that, see the House of Lords decision in Rabone and Penangir NHS Trust. Where either of those duties are engaged, the coroner will be under a duty to discharge what we call the investigative duty under Article 2, which has been placed in statute in Section 5.2 of the Coroners and Justice Act 2009. And in order to engage in investigative duty, all that one has to show is an arguable breach of the article. And for that, see Middleton in the House of Lords in 2004. What that means in practical terms is that the verdict can make judgmental findings upon the circumstances in which the deceased died, in addition to looking at causes of death in the direct chain of causation. So that's the basics of Article 2. And I want to move on and look at what may be one of the defining issues of the COVID-19 outbreak, and that's what's going on in care homes. Before I deal with Article 2 issues that may arise in care homes, I would just like to touch upon the coroner's duty to investigate, which the learned coroner has already addressed. And that's contained in Section 1 of the 2009 Act. And as the learned coroner said, it's a low threshold of a reason to suspect an unnatural death. During the outbreak of the coronavirus, the Shipman safeguards, and that's the requirement of 2 medical practitioners to sign a medical certificate of cause of death, have been suspended. So only one has to sign the certificate. And it's also been modified so that a doctor can sign a certificate if the deceased was seen within 28 days before death or has been seen after death. In my view, this creates a risk that deaths will be treated as natural deaths and not reported to the coroner by medical practitioners. If a coroner attended 28 days before death, they may not have seen symptoms of COVID-19, but can put that on the certificate following inquiries with care home staff. And so it may be that a medical practitioner doesn't report it to the coroner. If that happens in respect of a care home death, then somebody else needs to bring it to the attention of the senior coroner. In my view, in any care home death where the state is involved, there will be reason to suspect that it was unnatural and that an investigation should begin. One further point I wish to make on the investigative duty in Section 1 is that the lockdown itself may constitute compulsory detention that will trigger the duty to investigate. So there's one caveat to that, is that the duty to investigate is not engaged where somebody is lawfully detained under an authorization under the Mental Capacity Act 2005. But there may be people in care homes who are not the subject of an authorization, but who may lack capacity to make the complex decision of whether to consent to lockdown in a care home, because that decision requires knowledge of the risks and the ability to balance those considerations. So whilst a person may not generally lack capacity, they may lack capacity to make that particular decision. And so therefore they will have been compulsory detained. Likewise, children in care homes, etc., will be compulsory detained during the lockdown. And further, young adults with learning difficulties who are at residential colleges for most of the year may well lack capacity to consent to being locked down at college. And so compulsory detention may have to be considered in any of those cases. I move on now to deal with arguable breaches of Article 2 that may arise in care homes. The first obvious point to make is that where there is a breach, arguable breach of Article 2, there will also be a reason to suspect the death is unnatural, so that the coroner must investigate. The two are intrinsically linked. Local authorities are under a duty to meet the needs of adults if there is a risk of neglect, and that's Section 35 of the Social Services and Wellbeing Wales Act 2014, which I will call the 2014 Act. They're also under a duty to make inquiries where there is reasonable cause to suspect that a person is at risk of neglect, and for that see Section 126. Neglect is defined in Section 197 as a failure to meet basic needs, which is likely to result in impairment of well-being. Part 1 of the Statutory Code of Practice issued under the Act makes it plain that a failure to obtain healthcare can amount to neglect. And there are similar duties in respect of children, see sections 37 and section 130. It follows from that serious consideration may have to be given in due course as to whether local authorities who were providing care under the 2014 Act to people in care homes had reason to suspect that they faced an increased risk of contracting COVID-19 by virtue of their placement in a care home, because that arguably would meet the definition of neglect. Further, did local authorities have reason to suspect that persons in care homes were not receiving an equivalence of healthcare as those treated in hospital? If they did have reason to suspect that, then the duty in Section 126 to make inquiries as to what's going on in the care home would be engaged. And so the local authority would have to be proactive in circumstances where they suspected that a basic need was not being met in a care home. Where that duty is engaged under the 2014 Act, then arguably the operational duty under Article 2 of the Convention is engaged, because there may be an arguable real and immediate risk to life, and the issue will be whether the local authority took all reasonable steps to mitigate that risk to life. In addition to local authorities, the Care Inspectorate Wales has powers and duties of inspection of social care provision by virtue of the Regulation and Inspection of Social Care Wales Act 2016, which I will call the 2016 Act, and also under the 2014 Act on behalf of the Welsh Ministers. The statutory code under the 2016 Act, paragraphs 5.5 and 6.7, gives the Care Inspectorate, guides them into focused inspections at any time in response to a specific concern. Serious consideration may have to be given as to whether this regulatory framework functioned appropriately during the COVID-19 outbreak in respect of specific homes and perhaps more generally. What I mean by that is there may be reason to investigate whether the Care Inspectorate Wales were discharging their powers and duties of inspection in respect of care homes during the outbreak. Further, most care homes will have a nurse manager registered with Social Care Wales. They may hold responsibility for implementing safe systems of work within a care home. Inquests may have to investigate whether in any given care home there exist safe systems of work. Does the use of agency workers who work at more than one care home constitute a safe system of work? Was there a blanket policy of do not attempt resuscitation in any given care home? What constitutes a reasonable and proportionate system may vary from one care home to the next, depending on the size of the care home and the resources available. Further, local health boards provide nursing care in homes. what systems were adopted by those health boards to ensure that care home residents who required intensive treatment received it? Did care homes have all the necessary equipment, such as ventilators and so on? In any given case, were all reasonable steps taken to prevent the loss of life? Is the number of COVID-19 related deaths in care homes where there was no hospitalization justified? Further, in respect of health boards, it may be that sick people were discharged from hospital into care homes without having been tested for COVID-19. What steps were taken to isolate those persons as part of a safe system of work? And that applies to both the care home, the local authority, and the local health board. In relation to testing, was a decision made to prioritise the NHS? And was that a reasonable and proportionate decision? Why did it take until the 20th of April of this year to introduce routine testing in care homes? And why did any given care home have difficulty in obtaining testing kits, even after that introduction of testing? Did care homes and local health boards take all reasonable steps to provide carers and nurses with personal protective equipment? The Welsh Government has indicated that there were no problems with national stock, and so in any given inquest, the coroner may need to investigate whether there were isolated problems in any particular care homes and what caused the problems in the supply of personal protective equipment to frontline staff. So those are areas for investigation, in my view, arising out of care homes and the Article 2 investigative duty. Dealing briefly with prisons, deaths in custody will have to be investigated. It may be that coroners will want to receive evidence from the prison in their jurisdiction as to the systems adopted when confronted with a COVID-19 death, just to satisfy themselves that the systems in the prison were safe systems. Further, was personal protective equipment provided to prison staff? Not relevant to an inquest, but an inquiry may want to look at the conditions in which prisoners were detained during the lockdown and the use that was made of the early release scheme. Moving on now to look at schools briefly. Schools play an important role in safeguarding the welfare of children. Sections 25 and 28 of the Children Act 2004 require local authorities to promote the well-being of children. This overlaps the duties under the 2014 Act. The best interests of children have to be treated as a primary consideration under the 2014 Act. And insofar as the Welsh ministers have any duties in respect to education, the Welsh ministers have to treat the best interests of children as a primary consideration. The Education Act 2002 creates duties to safeguard and promote the welfare of children in maintained schools. Child protection issues arise under the Children Act 1989, where there is reasonable cause to suspect that a child or young person is suffering or is likely to suffer significant harm. Under the Education Inspections Act 2006, head teachers have a duty to adopt measures to prevent bullying, and this includes cyberbullying when children are at home. Anti-bullying statutory guidance has been issued by the Welsh ministers under Section 175 of the Education Act 2002, and local authorities must have regard to it. All this leads to this point, that in the case of a child or young person who has taken their own life during the lockdown, an inquest may well need to investigate what systems were put in place by schools and local authorities during the lockdown to discharge the statutory duties to which I've already referred. Were there systems, remote systems of working in relation to the welfare of children? There was a recent article in The Guardian that mentioned that referrals into child and adolescent mental health services had decreased by 40% during the lockdown. And it was said that a large proportion of that decrease was attributable to the fact that schools were closed. And so that's why, in my view, it becomes a relevant issue. Those are very quickly the areas that may require investigation under Article 2 of the European Convention of Human Rights. I want to now move on to deal briefly with the question of a Welsh statutory inquiry. Yesterday, the First Minister of Wales supported the principle of a public inquiry. In my view, that public inquiry would have to be held under the Inquiries Act 2005 and by the Welsh ministers rather than the UK ministers. Section 1 of the Inquiries Act says that a minister, which includes a Welsh minister, may cause an inquiry to be held under this Act, so there's a discretion, in relation to a case where it appears to him that A, particular events have caused or are capable of causing public concern. Well, there's no doubt that the COVID-19 outbreak satisfies that criteria, or B, there is public concern that particular events may have happened. Again, I think it's probably uncontentious that that criteria would be satisfied. Section 27 of the Act says that it applies to an inquiry for which the UK minister is responsible, and it says that the UK minister may not, without first consulting the relevant administration, include in the terms of reference anything that would require the inquiry to determine any fact that is wholly or primarily concerned with a Welsh matter. So what that means is the UK government can't hold a UK-wide statutory inquiry without consulting the Welsh government first, because many of the issues involved, for the reasons I've already explained, are devolved matters, they are Welsh matters. Section 29 deals with the ability of the Welsh government to hold a public inquiry, and that says that the terms of reference of a Welsh inquiry must not require it to determine any fact or make any recommendation that is not wholly or primarily concerned with a Welsh matter. For the reasons I've given, most of the issues that I've identified are Welsh matters. They're devolved: health, social care, and education. And subsection 5 of section 29 defines a Welsh matter as a matter in relation to which the Welsh ministers have functioned. Section 32 of the Act does permit a joint inquiry, so it is open to the Welsh Government and the UK Government to jointly hold an inquiry under the Act. The Chief Coroner's Guidance, number 37, indicates that it's the Chief Coroner's view that issues of national policy, as opposed to local policy, are not suitable for determination at an inquest. There is no dispute that issues of financial resources and policy do fall within the scope of the Article 2 investigative duty. That is a signpost that, in his view, national issues are better dealt with by an inquiry. Coroners will have to decide in any given case to what extent an inquiry must look at issues of resources and policy, bearing in mind that public authorities must adopt reasonable and proportionate systems which would include considerations of allocation of resources. If the coroner decides that certain of those issues fall outside the scope of his inquiry, then parties may wish to invite the coroner to write to the Welsh ministers requesting an inquiry under the Act. That happened in the Manchester bombing inquiry. And ideally, the coroner would wait for the response from the Welsh ministers before they decide on the scope of the inquiry. I think I've said enough and run out of time in relation to Article 2 and inquests and inquiries. Our next speaker is Lloyd Williams, Queen's Counsel. He's highly experienced in inquests and inquiries. Some of his inquests include the so-called cannibal killer case, the Cora Steel explosion, and the Emiliano Sala inquest. And he's also involved in the infected blood inquiry. He may or may not be appearing by video link. He may be audio only. We will find out now. Over to you. If you're there, Lloyd, you might need to unmute your microphone.
Yeah, I've unmuted him, so it might be your end, Lloyd.
You can't hear me, can you?
Yeah,
yes, we can now.
You can hear me. Can you see me?
Yes, thank you.
Right. Okay, well, good morning. It's Lloyd Williams here. I'm going to speak to you about inquiries from the perspective of the injured parties. Presently instructed by Mike Imperato and leading Christian in the infected blood inquiry, an inquiry that raises issues that are relevant to all inquiries, but which may be particularly pertinent in light of the present crisis caused by the COVID virus. The title, A Search for Justice, is taken from the title we gave to our opening remarks to the chair of the inquiry, Sir Bernard Langstaff. Sir Brian, as he's universally known and addressed by lawyers and court participants alike. It is, however, a theme that is particularly applicable to all inquiries. It goes beyond a search for the truth, because not only does it seek to explore issues that gave rise to the inquiry, past events, the facts of the inquiry, but it seeks to right any wrongs discovered. It seeks to set out a roadmap that others, usually the government, devolved otherwise, can use not only to ensure that the relevant matters complained of are properly investigated and not repeated, but also provide a means to compensate and care for the victims. The way in which this search for justice is undertaken can be understood, at least in part, by considering the infected blood inquiry. The inquiry is concerned with the provision of blood products from the 1970s to the early 1990s to a large number of people in the United Kingdom. Blood was contaminated with various viruses, including in particular hepatitis B, hepatitis C, and HIV. Those infected were, for the most part, already suffering from blood-related disorders, especially haemophilia, but also other similar conditions. Thus, they were people who had a pre-existing medical problem, which made them particularly vulnerable to these viruses, a problem exacerbated by their need for regular treatment with blood products. Without treatment by these blood products, they faced serious harm or death. Contaminated blood was also given to others by blood transfusion following injury or surgery. Through these various means, thousands were contaminated. Thousands have died. It's estimated that one victim dies every 4 days. Tens of thousands have been affected by their loved ones receiving contaminated blood. Some have become infected by contact with the primary victims. The blood became infected primarily because the blood was purchased from American companies who in turn had bought it from donors who were prisoners and therefore were at a substantial risk of being intravenous drug users and therefore infected with hepatitis C and HIV. This problem was compounded by the manner in which the blood products were produced, which involved the mixing of blood with thousands of donors to create a batch of blood products. This was a worldwide scandal, not just in the United Kingdom. It's often said that the blood inquiry is unique. One hopes it is. It'd be appalling if a medical disaster on such a scale were to be repeated. However, the structure of the inquiry, the form it takes, is a general application to all inquiries, although the sheer size of the inquiry tends to highlight particular issues. It's interesting to compare the situation which might exist if there was to be an inquiry into the circumstances raised by Christian, a COVID-induced crisis in care homes. The primary reason the blood inquiry is described as unique is the sheer number of issues and the quantity of evidence that Sir Brian will have to consider. This is a result of the wide-ranging nature of the scandal. It resulted in the contamination of thousands in this country. It has affected tens of thousands. It was worldwide, not just in the sense that the scandal is replicated in many countries, but also that the inquiry intends to consider the actions and decisions of people and institutions in this country, but also those abroad, particularly American drugs companies. The primary period which the inquiry will consider is from 1970 to now, so some 50 years. There were numerous parties whose decisions and actions may have played a part in creating and perpetuating this scandal. The scandal not only includes the initial contamination with infected blood, but also what attempts were made to deal with the medical consequences of infection, attempts to cover up or deflect attention away from the true causes of infection, and the way in which government has supported the victims. It includes central government, including, we hope, former cabinet ministers, Department of Health, devolved bodies, NHS trusts, local authorities, individual hospitals, individual clinicians, as well as various regulatory bodies, charities and companies. Given the number and type of parties involved, it will come to nobody's surprise, I'm sure, to be told that even though many crucial documents have been shredded and putting to one side the victim's own medical records, there are still well over 1 million documents, some only of 1 page, others running to 50 to 100 pages. The amount of material to be considered is immense. The inquiry has set itself the task of investigating a large number of issues. They fill some 66 pages, with the numbers of issues exceeding 500. Clearly, there are similarities here with any inquiry into the COVID virus in care homes. It raises important public health issues arising from the spread of a virus amongst a vulnerable group, and a group that was known to be vulnerable. Any such inquiry into the virus will require an investigation of the role of government at all levels, central, devolved, and local. It will involve an exploration of the role of regulatory bodies. It will need to consider the role of other bodies, including health authorities, individual hospitals, and clinicians. Want to know why people were discharged from hospital into care homes without any or any sensible precautions having been recommended or taken. It will need to consider what, if any, strategic planning had taken place with regard to such a pandemic, what precautions had been taken, what precautions ought to have been taken, what was the decision-making process, what was the policy decided upon to protect those in care homes. Necessarily, it will include an investigation into what protective equipment should have been provided, what tests should have been recommended, what tests were provided, what reviewing process was in place, particularly in view of recent admissions made by Robert Buckland. Why were those in care given a lower priority than those in hospitals? In the blood inquiry, we represent some 200 core participants, those entitled to play a part in the proceedings, the equivalent of a properly interested person in an inquest. 2 of our core participants, charities, the Haemophilia Wales and Haemophilia Northern Ireland, and through them we represent many more individuals. Many of these are seriously ill. Many will have cared for seriously ill members of their family for decades. All of them have lived with the consequences of contaminated blood for decades. For obvious reasons, they are suspicious of public institutions and bodies, whether central, devolved, or local. Suspicious of experts. It was, after all, the experts who placed them in a position of risk that caused they or their loved ones to be infected by contaminated blood. And they've been ignored for decades. Their attempts to get compensation for there to be a public inquiry have been rebuffed for decades. They have an overwhelming sense of injustice, and it is this search for justice that has driven their campaigning for the inquiry for over 30 years. And it is our role to make sure that they get what they seek, that they get justice. A very important element of this is that they need to be listened to. For too long, they've been told to be quiet, to be grateful for whatever pittance by way of support the government has given them, and told not to complain. This need to be heard takes many forms. They need to tell their story to the public by way of giving evidence, either orally or by written statements. Sir Brian has endeavoured to make sure that takes place. Nearly 200 have given evidence. Many more will do so before the end of the inquiry. The structure of the inquiry, the way it operates, has some similarities to inquests. In particular, they are both inquisitorial in nature, but an inquiry has some significant differences. The Inquiry Rules 2006 provides that only counsel to the inquiry may ask questions. Lawyers representing the participants can only seek to question a witness if they cannot persuade counsel to the inquiry to ask the relevant questions. From what we've seen so far, it seems unlikely that Sir Brian will be exercising that discretion very often. So far, the only evidence we've heard has been that of the victims and some expert evidence of an uncontroversial nature. Sir Brian has adopted an interesting approach to the oral evidence given by the victims. Basically, they can give such evidence as they see fit. There are none of the evidential rules that one might expect to find. So hearsay rules do not apply. Witnesses are allowed to speculate or even guess what might have occurred 30 to 40 years ago, sometimes in respect of events that occurred before they were born. They can give their own opinion on complex medical issues of diagnosis, causation, and prognosis. They can speculate as to the reasons why parties and institutions acted in the way they did. They can speculate on motive and intent. Counsel to the inquiry leads them through their witness statement. No one can cross-examine them, and for the most part, their evidence goes completely unchallenged. Why has he adopted this approach? It seems to be because he recognizes that the victims need to have their say. They need to tell their story, unrestrained by the technicalities of rules of evidence. Having spent 40 years or more disbelieved by the medical profession, having been ignored by the politicians, having been stigmatized for medical conditions they've suffered caused by the actions of others, now they can have their say. However, all actions have their consequences. Adopting such an approach seems to imply that Sir Brian will not be making specific findings of fact in respect of every allegation made. So when Mr. X says that Dr. Y did or didn't do something, that evidence will be taken into account. It will add to all the other evidence he hears or reads. It may or may not add weight to a particular view as to how doctors are acting at a particular time. But in the absence of some form of cross-examination, it seems unlikely that he will resolve every contested issue of fact. And this identifies an important difference between inquiries and ordinary litigation, even an inquest. It inevitably means that issues of fact that may be very important to an individual will not be resolved. The evidence of an individual is important, but only insofar as their evidence assists with establishing the broader picture. Notwithstanding the fact that we're not permitted to ask questions of those we represent or those whose evidence we may wish to challenge, we, the lawyers, have had an important role to play in the giving of evidence. Mike and his team have taken and submitted hundreds of statements adhering to a complex set of rules as to how the evidence should be set out. Christian and I have reviewed numerous sets of medical records of the witnesses to be called. Some records are voluminous, some gutted of all the most relevant parts. We meet with those witnesses to consider their evidence and the parts they wish to emphasize. We prepare an outline of relevant entries in the notes, which are then attached to copies of some of the documents. This is sent to counsel for the inquiry, who uses it to help her prepare her questions. This search for justice, the need to be heard, has been reflected in our relationship with those we represent. There must be clear communication between us. Communication is necessarily a two-way process. It's not for us to lecture to them as to the matters being investigated. For them, this disaster has been a lived experience. Many of them have considerable knowledge of the matters that need to be examined. They've spent years researching this matter, alone or in groups. They can speak about matters with some degree of knowledge and expertise. Mike's team keeps in regular contact with individuals we represent, asking for more information or answering queries about the inquiry. Christian and I regularly attend meetings with our clients. They mostly live in Wales and Northern Ireland, so our meetings are in Cardiff and Belfast. They're unlike any of the conferences I've attended. Although they start with the usual formality of such an event, they soon transform themselves into a general discussion, where whoever wishes to speak, ask a question, or make a comment can do so. They usually take not less than 3 hours, by which time we've all talked ourselves out. It sounds a cumbersome exercise, but it isn't. It was following meetings of this nature that we could get the substance of our clients' concerns that Christian and I used to prepare our detailed opening remarks. We're dealing with intelligent, sensible people who are united in their search for justice, and through us they can make a real contribution to the inquiry. Throughout the last 2 years, counsel to the inquiry has contacted us to ask our opinion as to which matters should be included in the list of issues, which experts are to be instructed, There are usually 7 or 8 experts on any particular topic. We're asked about what issues or questions should be raised with experts when they prepare their reports. What questions should be put to them when they come to give oral evidence? We ask our clients about these matters. We consider their replies and reduce them to a manageable state, and then send it on to the inquiry team. And this is our real role. We're a means of communication between the inquiry and those we represent. We can keep our clients informed about developments in the inquiry, explain what is happening, and then take their views on these various issues and pass them on to the inquiry. Why is this important, this need for communication? One need only compare the blood inquiry to the Grenfell inquiry, where rows regularly occur between one or more of the groups of core participants and the chair, or between each other. It shows a complete breakdown in mutual trust, and that is a real tragedy. If an inquiry is to do its job properly, then it must maintain the trust and confidence of the general public, and it will only do so if it maintains the trust and confidence of the core participants. Our role is to help maintain that vital link between the inquiry and the core participants we represent. Thank you very much.
Thank you very much, Lloyd, again for that very interesting segment. The next speaker is Ruth Henke QC, who's going to give the flip side of that and talk of her experience of representing a criticised institution in the independent inquiry into child sexual abuse. Ruth is the foremost expert on all things children, vulnerable adults, and deprivation of liberty. Ruth Henke, thank you very much. Ruth, I think you need to unmute your your microphone.
Yeah, I've unmuted Ruth, so I don't know if she's frozen actually. I don't know if she's frozen.
Whilst we resolve those technical issues, perhaps we can interpose Michael with his talk, and then we'll try and get Ruth back. Many of you know Ruth.
Oh,
there's Ruth. There we go.
Convenient that I talk now, Christian?
Yes, please, Ruth. I just introduced you, so please take it away.
And everyone at the end can tell me what he said about me, his head of chambers, whilst I wasn't able to hear. But until we get to that point, let me introduce myself. I'm Ruth, and I'm a specialist in the law concerning children and vulnerable adults, and they are likely to be the focus of a number of issues that arise out of COVID-19 and the state's handling of that, be it in the form of national government or local government. If you don't know me through practice, you may have seen my name. I was responsible with others for the policy guidance under Part 7 of the Social Services and Wellbeing Act 2014 and the statutory scheme that falls from that. I am also the author of the Welsh materials for 3 legal textbooks dealing with social care for children and vulnerable adults. My talk is a practitioner's talk of pragmatic steps to take. 9 steps I'm going to advise you to take should you become involved in an inquiry. And I'm going to base it and found it on my experience of acting in inquiries, which I first gained back in 2001 when I was actually counsel to the inquiry into child protection in the NHS in Wales. And that, for those of you that may recall, was the offshoot of the Waterhouse inquiry into abuse in care homes in North Wales. And most recently, my name made the national press because I represented Ealing Abbey in the inquiry into child sexual abuse that was, until COVID-19 struck, continuing. And I'm going to use that as a basis for how to respond to the inquiry. And the first step is to be involved, if you can be, in the scoping of that inquiry, be it what I would term an administrative inquiry, which the inquiry in 2001 into child protection in the NHS in Wales was, or be it a full-blown public inquiry. There will be consultation, and if you are likely to be a core participant, make sure that you take that opportunity. Firstly, you don't want the expense of missing something that needs scrutiny being missed. You may think that is a minor matter in the grand scheme of things, but that 2001 inquiry had to take place after the Waterhouse inquiry because the scope of the Waterhouse inquiry had been confined to social care, and it left out those institutions in which children were accommodated run by health. It is important to get the scope correct. The emphasis of any inquiry will be the search for justice, but it isn't always just that. It is also about learning lessons for the future. There is no point having an expensive, protracted inquiry looking at past mistakes under brutally sharp light if you then do not learn from those mistakes. And the public will expect to learn from those mistakes. And you must take that into account if you are going to be responding as a core participant from the very start. It should inform your thinking of the myriad of papers. And like Lloyd, I'd like to emphasise how many pieces of papers there will be. In the last month before the inquiry into Ealing Abbey started in earnest in the form of the inquiry taking place itself, I was served with 33,000 documents. That was against a baseline of many hundreds of thousands of documents. And so step one, from a practitioner's point of view, if you are likely to be a core participant with a case to answer, is manage your own papers. You already have them under your own control. Make sure they are already collated. Make sure they are in a form which, if they need to be disclosed, they can be disclosed easily, quickly, efficiently, and in, hopefully, chronological order. 33,000 documents that might have well have been thrown up in the air and then landed and put into some random digital file helps no one whatsoever. It certainly doesn't help you narrow the issues and state your position upon them. You need, at the very beginning, if you are likely to be a core participant, to look at your own papers and start making what I would term an overarching chronology. It will be painstaking. It will be time well spent. Firstly, you will be able to see clearly gaps in the disclosure for which you will be responsible. It shows that from the start you are taking it seriously. It also means that you are on the front foot, not the back, and you have some degree of control, rather than being the miscreant core participant who is already suffering from adverse public opinion, who is late in disclosure and can't find documents. That's not going to help your cause, and it doesn't help the public cause. And you have to be brutal from day one in your analysis of your own part in what the inquiry is going to be looking at. There is no point whatsoever in having rose-tinted spectacles. It will come out, and it is better that it comes out through you. If you have that chronology, you can also start looking at the context. And as other core participants make their disclosure, often in large tranches, you can start fitting in what they have done, what they have disclosed, into what you know of your own actions and inactions. That enables you to start seeing patterns. If, and this is the brutal honesty that you must apply to your own actions and inactions, those have been influenced by the actions or inactions of others, they will start to become clear on the documents. Step 2 is therefore, in my recommendation, ensuring you manage each and every tranche of the papers that come from the other core participants. And begin to think about what you want from others. Because if you've managed your own papers and that which they have voluntarily disclosed, you can start to say, and I would now like to see X or Y. And you can start to put your case. If you've done that, you can move to step 3 quite easily, because you will be required as a core participant at some stage to put together witness statements. And they've got to address the issues fairly and frankly, but they have also to be accurate. Credibility is going to be key. These are now going to be serious issues subject to in-depth public scrutiny, both of the media and of the inquiry. If you lose your credibility, then you lose public confidence and you lose the confidence of the inquiry. It is key. And if you cannot see where each piece of the jigsaw fits into that overarching chronology, you will make mistakes. Do not think that anyone is exempt from it. As those of you that may have followed the press reports into the Ealing Abbey part of the inquiry may know, the then abbot of the abbey, who was not subject to any allegation of abuse and whose past had apparently been blameless, had not mastered his documents. He made a fundamental error. He gave evidence to the inquiry, and at the end of it, he was no longer an abbot, because he had made a huge error that dented the credibility of the institution. Do not be the abbot. Step 4, framing questions. Lloyd's already touched upon this. If this is a public inquiry, as an advocate on behalf of the court participant responding, you will not be framing your own questions. Someone else will be. You want counsel for the inquiry to take what you say seriously and, if possible, and you have their confidence, to use how you frame the questions. And so you have to identify not just what you want to ask, but why you want to ask it, provide all the documents that go to it in a nice, neat little pile so that relevant witnesses can have it. You can do that if you've done your chronology. I cannot emphasize how important that overarching chronology is. Because once the inquiry is up and running, if you're a core participant, unless you're going to be there throughout it all, like Ealing Abbey in the inquiry into child sexual abuse, you'll have 5 days to put your case and for your witnesses to be examined. But everyone else may be seeing the entire picture, and you are going to have to work very quickly in the end. Months and months of waiting, coming to a very sharp point, and you've got to be ready, because in a crisis, you cannot simply start searching through hundreds and thousands, possibly millions of documents. Step 5, addressing the inquiry. Start thinking about that from the get-go. You're going to be addressing the inquiry at some point on 2 levels, orally and in writing. And the written document is very much like some of you may be familiar with when you're writing submissions for court. But the oral submission is very different, because you're not addressing necessarily just the tribunal, but the press. It's going to be open, there's going to be public interest, and you've got to be able to pitch it to those that you are seeking to persuade within the room and those outside, because you're representing an institution which, if you're part of the Catholic Church and part of that inquiry, is under significant scrutiny and, frankly, the object of hatred. It was obvious as I rose to my feet, and I've represented many people who have done some dreadful things over the time and been found to have done them. But when you rise to your feet and you're representing a core participant, you feel the weight of the criticism of the public upon that institution. So how do you do that? Well, first of all, everything has got to be done in advance in a way that for perhaps a normal court hearing, you might not anticipate. You need to get your written submissions honed down well in advance of ever being expected to do the oral submissions, because they will form the foundation of what you're going to say. But if you're representing a court participant who is large and subject perhaps to much public criticism, you're likely to have a public relations team, a media team, and they're going to want to know what you're going to say because it's going to be reported in the press. That all needs to be anticipated. You also need to remember that certainly if you're counsel, you act without fear or favour, and your duty is to your client. How can you best fulfil that, especially when the horror of the world is focused upon your client? Well, you've already done your overarching chronology, you've worked out the issues, and you've already had that discussion because you've had to meet the issues of actually what went wrong. You may want to apologise. Never ever apologise unless you mean it and you have substance to it. What are you apologising for? Why are you apologising for it? Is that simply falling on your sword on the basis that it's all going to go away? No, it's about honing the focus of the inquiry upon that where you do have a case to put. Because it is very easy when you are subject to criticism for the whole barrel to be thrown upon your client, and some of it may be justified and some not. And you need to make sure the inquiry focuses on actually, they may have made mistakes, but some of what they're accused of isn't right. And you do that by making realistic apologies based on substance and evidence. What else need you to be doing if you're a core participant responding to what has been called an inquiry because something has gone wrong? You don't wait to be told to put something right. You do it, and you do it as soon as you realise it's wrong. You do it because that is the right thing to do. You also do it because then you can go to the inquiry and say in your opening, we have looked at the papers, we apologise for this, because we did X, Y, and Z, and we have already shone our torch on it, and we put our hands up to it. But actually, we didn't do this. You cannot scapegoat us for everything, and we're now going to shine the light back on you. Because no one participant is going to be responsible for any crisis that comes to a public inquiry. There will be a number of factors that have interplayed. And you need to be able, when you are responding, to be able to shine that light back. And you can only do it if your own house is in order. Step 8. Don't just say you recognise what's gone wrong and apologise. Show you mean it by having put it right. And show how it works. Because whilst the press made a lot about what had gone wrong in the Catholic Church and in the Abbey in particular, and it's all in the public domain, so I can speak about it, what had happened since it came to light, since the incumbent abbot of the time, when the sexual abuse had been occurring, had gone on the run and had been, it was said, hidden by the Vatican, was that since then, and since all the press attention, they had put their house in order. And the school that they ran was now actually a model of how a school should be run to protect the children within it. Because there is nothing like being subject to that degree of scrutiny to make you put your house in order. But when you've done it, why not say to others, actually, yes. And you can say it when you've represented the Catholic Church, as I did. We have sinned, but we recognise it. We are sorry, and we're doing our very best to put it right. And here, we've done it. And so those are the steps I wanted to bring to your attention. Take each and every one of them. And whatever you do, don't leave it to the last minute, because the last minute in a public inquiry just doesn't exist. Thank you very much.
Thank you very much, Ruth, for that very clear advice. The next speaker is Michael Imperato. He's a go-to claimant public lawyer in Wales. As you've heard, he's involved in the infected blood inquiry. He's heavily involved with Inquests, and so carries out a lot of inquests in Wales and across the United Kingdom in relation to children and vulnerable adults. And Michael's going to discuss largely reopening inquest. Thank you, Michael.
Hi, great, thanks. Trust everyone can hear me okay. Now I'm going to try and be really technical and share a screen here. Host has disabled it. So can I share?
Should be able to. 2 seconds. I'll just
Yeah.
There we go. There you go.
Right. Okay. Yeah. Here we go. So right. So just want to get a quick couple of slides basically on this. Slideshow. So reopening and challenging an inquest. A phrase you will hear is the Attorney General's Fiat, and that's my car. Don't make as much money as the barristers, so that's what I drive around in. It's basically Section 13 of the Coroner's Act is the key to reopening an inquest, which was historic, which has been heard in the past. I'm going to rattle through this, but if people want a copy of my slides, they can always email me. Section 13 sets out two provisions for that. So you can challenge a coroner in that respect who's refusing, and basically where the main one is where it's desirable in the interest of justice that another investigation be held. So the key thing to remember then is that it's the High Court that may order the investigation to reopen the inquest, and that's their powers there. They can quash the original determination in those circumstances. The Attorney General must make the application to the High Court or authorise a third party by way of a fiat. So that's where the word fiat comes in. Fiat is consent. So it's the High Court, not the Attorney, but it's the High Court, not the Attorney General, which then makes the decision as to whether or not to order a new investigation. Now, the classic example, and we've been talking about inquests and the like, well, a classic example is Hillsborough. That was a high-profile example, 2012. Everybody knows about Hillsborough, I assume. So there was new evidence, both medical evidence and issues about the tampering of witness statements and the like. So so that went to the High Court, and we had Lord Judge, the most appropriate named judge you could have. Lord Judge gave the kind of definitive answer to this, where he said that the real test is the single question of whether the interests of justice make a further inquest necessary or desirable. And he actually said that it's not interesting, it's not a precondition that a different verdict has to emerge. There's the reference there. And the critical paragraph is paragraph 10. That's really the classic test set down by Lord Judge. Now, are there any limits? This is No Limits. That's the famous pop group from the 1990s, 2 Unlimited, who had the hit single with "There's No Limits." Well, are there no limits? So there's Section 13 does not specify a time limit for any event. So we've had a very recent case of Frost and against the coroner for West Yorkshire, where the High Court ordered a fresh inquest to be held after 53 years. And that was a tragic case. That was one of those terrible cases of somebody who was, a child was killed, a chap was accused of the murder. It turns out that he wasn't the murderer. The real murderer then dies. So there was a call for a fresh inquest into all this. And interestingly, the coroner wasn't very keen on this. He actually questioned the value of a fresh inquest, and so he wasn't helpful at all. So the family had to get into their fiat, and they made the application to the court. But the High Court was very sympathetic and said that 53 years is not a problem, and that the getting to the truth was the key thing on all this. So I think that's interesting that you can really look to try and reopen matters which, on the face of it, are quite historic and quite old. One what happens if the Attorney General won't put the fiat in gear? What if you apply to the Attorney General, but he says no? That's a case of Little, the Attorney General, where a kind of hospital setting case, and in this one, the Attorney General declined to give his fiat. So the aggrieved family then judicially reviewed that decision, and Mr. Justice Lane resoundingly dismissed the application as hopeless and awarded costs against the claimant. So he was trying to send a very, very strong message that not to challenge the Attorney General's reluctance. And he said, Justice Lane said, the Attorney General's refusal is not susceptible to judicial review. He is answerable in this regard to Parliament and the admin court. Now, I think that's an interesting point, and there are people who question that assertion. So it might be that that concept might be challenged in the future. But certainly, you have an uphill battle. Is the message? It's if the Attorney General is not helpful to you. Perhaps you should bring a judicial review instead. And this is the tragic case of Jones and the coroner for Gwent, which is the young lad who died of the E. coli poisoning. And this is where is a judicial review the correct vehicle rather than a Section 13? So this case does touch on that. So Mason Jones was only 5 years old. He ate the infected meat, tragically died. The CPS decided they weren't going to make a conviction of do any kind of manslaughter convictions of the meat company, and the coroner at the inquest held that an unlawful killing verdict could not be considered, and so gave a narrative verdict. 2 years later, the DPP accepted there had been an error in their original charging decision. There was sufficient evidence to have gone with a gross negligence manslaughter. So the family then tried to go through Section 13 to reopen the inquest. But the court, the High Court, because it's the High Court who makes the decision, they were not sympathetic. The court said that the real complaint now was being made that the coroner had reached a conclusion which was not properly open to him on the evidence. And so basically, they said, well, you should have brought a judicial review at the time. Now you're bringing a Section 13 to try and get round the time limits of judicial review. So the family was shut out for that reason. Judicial review, I imagine that all people here know all about judicial review. You're more concerned with issues of procedure. It's a legal challenge. The 3 months is the critical thing there. Don't forget 3 months, very tight time limits on judicial review, so don't hang about. Just very quickly on this, that again, judicial review is not easy if you're challenging management decisions, and this is the case of Maguire and the coroner for West Yorkshire. Seems to be a lot of stuff going on in Yorkshire in these cases. I'll just go back. That was a terrible. That's the case of the teacher who was stabbed by a pupil, and this was all about the evidence. Whether evidence should be put in from pupils at the time, and so the coroner made various rulings about how that evidence should be dealt with, and the family challenged it, but the courts were not keen on dealing with these kind of case management decisions of the coroner. But it's more fruitful, of course, if you're looking at a question of law. And I just flagged this case up of Morn because it's the high-profile one that's going through the court process at the moment about standard of proof in an inquest in suicide. Effectively clarifying that should be a civil standard of proof. That case, though, is going to the Supreme Court, and so expect that to be heard shortly in the Supreme Court. So that's a classic question of law case, which judicial review is clearly relevant for. And of course, we've had a lot of talk about public inquiries. Well, a coroner can suspend an investigation if there's going to be likely to be a public inquiry. There's also interesting a case of the tragic case of Alexander Lichenko, and that was where, in that case, a public inquiry replaced an inquest, where it was clear the inquest could not properly inquire into things because there was a lot of closed evidence that had to be given. So this was all about, that was the chap who was poisoned with poisoned by the Russians allegedly. I hope there's no Russians listening in on my computer, but he was poisoned allegedly by the Russians, and so there was obviously a lot of kind of intelligence stuff that had to be heard and considered. There also, public inquiry can be preferable to an inquest where there's wider issues to be dealt with. And another example, again a similar example, was the Stephen Lawrence case, where another example where an inquest has taken place, but there was need to investigate the case afresh, and that was because it followed the Macpherson inquiry, which was all about alleged racism in the Met Police. So those are examples of situations where we've gone into inquest inquiry post inquest. And I just want to conclude. I'm sorry I've rattled through this very quickly, but I was conscious of the time. That in 2014, the House of Lords Select Committee concluded that where public concerns extend significantly beyond the death itself to wider related issues, an inquiry may be preferable to an inquest. And I think that leads us right back to what people have been saying earlier on about the COVID crisis, of course, we're currently facing. So thank you. So sorry, that was a very quick rattle through, but I hope that gives some idea on the reopening of an inquest and the link with judicial review and the link with public inquiries. Thanks.
Thank you, Mike, for your clear and always humorous talks. We do have time if people want to ask any questions. If anybody needs to leave, then please do so. Either you can use the chat function or just unmute yourself and ask a question. So I'm going to give anybody the opportunity to ask any questions that they have.
I've had one sent in from an attendee who can't make it from the Equality and Human Rights Commission. She said, could you ask the speaker's views about the recording of ethnicity on death certificates relevant to the Public Health England and Wales inquiry about more BAME deaths due to COVID, so BAME, sorry. I'm going to unmute some of the speakers to see if they can respond. Did you hear that okay?
Yes, Emma, thank you. Perhaps, sir, you would like to answer that question?
Well, as far as I'm aware at the moment, and I'll be corrected on this, I don't think there's any particular place for ethnicity to be set out in a death certificate. And I can be corrected on that, but I've not seen a death certificate that actually has that on it. I suppose it's a good question. All I can say that I'm like everybody watching media reports, and there's some suggestion at the moment that certain ethnic groups have more prevalent numbers of COVID testing. I suppose from a coronial perspective, that it's certainly that question would not be one within the questions that a coroner would be statutorily obliged to answer within Section 5 of the Coroners and Justice Act. So, from a legal coroner perspective, I can't see how there is a provision to record that. But I don't know whether the speakers have a view as to whether it should be or ought to be.
I think I agree with you, sir, that it's not something that goes to ascertaining whether the death was natural or unnatural. It isn't something that I would have thought an inquest would be suited to look at. It is obviously something that is better addressed in a public inquiry, because that is an issue that causes public concern, and it's an issue that could only be looked at a higher level. I also have in mind, actually, that in addressing that issue, whether the government would have to keep in mind its public sector equality duty, and actually what is the government going to do about looking at that particular issue. And I think actually the Equality Act 2010 might come into play there.
Thank you, I'll pass that on.
Does anybody else want to add anything to that?
Yeah, it's not add to, it's looking at it from a different perspective. because I come across the registration of births, marriages and deaths for a completely different purpose. And I've had to ask myself when dealing with cases, what is the purpose of registration and the information that's given? And the purpose and the reason behind the statute is actually census. It's about working out the numbers of population, where they are, so that services can be provided. You don't record on a birth certificate the ethnicity or the religious orientation of the parents of a child, and so you wouldn't record it on the death, be it of a child or an adult. So the whole purpose of registration is simply census. It comes from the Industrial Revolution. I won't bore people about it. I had to research it. But actually it was people moving from the country into the towns where they needed health provision, social care, housing. And so you could find them. And that's why you have registration. So I don't think it should be on a death certificate. I don't think it is a matter for the coroner, because actually you have to look at the purpose of registration.
Thank you.
Thank you. Unless anybody else wants to help answer that question.
Can I raise a question? It's Peter Davis here from JCP Solicitors. We are looking ahead and anticipating, I suppose, that there will be either one or probably countless inquiries into COVID, where the public institutions, whether this be the UK government, the government in Wales, Scotland, Northern Ireland, countless local authorities, countless privately run care homes, schools possibly, and goodness knows whatever else will be in the firing line. Won't such an inquiry be totally unwieldy to run, whether on a pan-Wales basis only, let alone on a pan-UK basis? Because people, rightly or wrongly, will want to be heard. People will want to hire lawyers to voice their concerns and so forth. Inquiries are going to have to be sort of compartmentalized, it seems to me, because otherwise, such an inquiry, it's not going to be like a fire in a block of flats in West London, or even Chilcot for that matter, which was quite specific in one sense, albeit that it was looking into the history of the war in Iraq. But a COVID UK inquiry seems to me to be something that's going to go on for years and years and years and years.
Well, I can give a short answer, and then hopefully other people can supplement it. If you look at the Grenfell inquiry, that's split into themes. And so core participants will come in and out of the inquiry as a theme that the inquiry is dealing with at any point in time is relevant to them. But also, it's for the chairperson of the inquiry to decide who are core participants. And so core participants will generally be institutions, organisations that are going to be criticised and have the procedural right to respond. But also people who can add to the inquiry's work. So just because you want to be a core participant, it doesn't mean that you will be granted core participant status. So that is a way by which the chair can control the number of core participants. Being a core participant doesn't mean that you're not a witness. So for example, in an infected blood inquiry, although there are a large number of core participants, one way of dealing with it is making sure that everybody has their voice, and so they can give evidence to the inquiry. The inquiry considers all the written evidence, but they don't need to be core participants. So the mechanism is there in the Act to allow management of the inquiry, one, to split into phases, and so you reduce the number of people who have to be there at any given time, but also actually restricting the overall number of core participants to that which is required to further the inquiry's work. And I'll hand over to anybody else who wants to add to that.
Can I say something, Christian, as well, that one of the main things they did in the blood inquiry was to restrict the number of lawyers involved as well, because you had designated firms, so you haven't got dozens and dozens and dozens of law firms all involved. So that was something which was done early on. So the several hundred victims were represented by 5 or 6 law firms. So that kind of cuts a lot of the babble down. And but the other thing which Christian touched on in his talk, which I think is a really interesting issue that's going to come up, is the devolution issue here, because, as Christian said, much of what where we want to examine is devolved. Much, if not virtually all, is devolved. Now, this is going to be the first time I'm really aware of something which does affect the whole country, but breaks down into the individual responsibilities. That's going to be, I think, the really fascinating thing. And I can imagine that Scotland, for example, will want to do their own thing. They won't want to be tied into to Boris and his mates. So that's going to be a very interesting dynamic of whether we have 4 entirely separate inquiries. If you're going to try and have one big inquiry, how do you manage the devolution issue? That, I think, is going to be really fascinating.
Yes, can I just comment on that? The blood inquiry is a good example of how inquiries are specifically developed for this type of very large number of issues. As I said, in the blood inquiry, we have over 500 or more issues that the inquiry will have to consider. Compared to the blood inquiry, I think any inquiry into the COVID virus will be fairly small beer. We're considering in the blood inquiry events over 50 odd years, numerous institutions, numerous bodies, thousands of people who are interested in the outcome of the inquiry. So I don't see there being any problem for an inquiry looking into these matters. Indeed, it's the very device that's been created to allow an investigation into this type of matter. And the number of interested parties will be met by such orders as the chairman seeks to give. So far as the devolution issue, Mike, as you know, there are devolution issues in the blood inquiry as well, because although the events that we're primarily concerned about in the 70s and 80s occurred before devolution came about, the way in which the victims have been treated in the 1990s, 2000s, have been primarily dictated by the devolved assemblies, Parliament. And so the chairman, Sir Brian, is going to investigate the actions of the devolved governments to see what they've been doing to support the victims. So there is some precedent for one central inquiry, looking at the response of the UK as a whole, but also looking into the actions of the various devolved systems of government, and of course into the actions of local authorities and local health authorities. So on a nationwide basis, but also taking into account the various devolved institutions that exist. So I think it can be done. And can I just say, the question, the preliminary point introduction by the person who asked the question, one can only hope that any inquiry will last for years and years so as to provide work for hard-working lawyers. Thank you.
Does anybody have any further questions? Or does that answer your question, Peter, or do you have any comeback questions? I feel like I'm on the daily briefing.
Yes, I can see. I think the first thing that any inquiry will have to consider is how much of an insurance premium they have to pay for the chairman or chairperson, on the basis that in reality, if it's an inquiry, it's going to go on and on and on. Having been involved in some inquiries in the past where sadly the chairperson hasn't been able to complete the inquiry either because of failing health and or death. That's the starting point for the ministers in establishing any inquiry, I suspect. But even if it was a Pan Wales inquiry, there, as Mike will know, there will be some core firms who will establish a group of interested parties, and lo and behold, they will turn up, asked to be represented, and ask for remuneration from the inquiry for said representation. So came to Lloyd's point, I suppose, the lawyers will want it to be looked after, but putting those issues to one side for the moment in terms of lawyers being properly remunerated for representing people with proper interests and so on, my fear is that this inquiry will become unwieldy, because if the Welsh Government, for example, were to host an inquiry, or to hold an inquiry rather, dealing with health, education and social care issues, it will become, I think, far too complicated. But be that as it may, let's wait and see.
The other potential issue, I mean, I agree with Michael that given that the approach of the Welsh Government and its response to the COVID-19 outbreak has diverged from the approach of England, actually, it makes a lot of sense that it has its own statutory inquiry, because there are different issues at play, and it makes no sense having one large public inquiry looking at discrete administrations. You may as well have that administration looking at it for itself concurrently. And so all inquiries, if you do it that way, would come to an end sooner. And with the infected blood inquiry, there's always a tension between reasonable thoroughness of the investigation, but actually getting it in a timescale done that suits the needs of everybody involved. You don't want an inquiry going on and on and on, but the right balance has to be struck between investigating the issues with reasonable thoroughness, but also reaching your conclusions in a timely manner, because if lessons are to be learned from these events, they need to be learned as soon as possible, so that the mistakes can be righted before any other pandemics occur, so that mistakes don't happen again. So there is always this tension between thoroughness but timeliness. And I think that one major reason for the Welsh Government to hold its own statutory inquiry is timeliness. Otherwise, if it's joint with the UK, I fear that it could go on far too long.
One of the problems, though, with having a devolved approach to this is, as we found with the blood inquiry, as you know, Christian, there had previously been an inquiry held in Scotland just dealing with blood contamination in Scotland. And in that instance, the inquiry was captured by vested interests in Scotland, which had an effect of creating a bias in respect to the final report, bias towards the medical establishment. One of the problems of being in a small legal jurisdiction, as we are in Wales, is the very real risk that government, who will be in the firing line, devolved government, local authority, local institutions, will seek to capture and create a bias in the inquiry and in the outcome of any inquiry, which is why perhaps in the interest of justice, a UK-wide inquiry may better meet the needs of those who were victims of the COVID virus, and will also prevent the devolved government hiding behind the existence of central government and blaming them for whatever has occurred, and rather than accepting their own apportionment of blame. So I think a UK-wide inquiry has its benefits, although I accept the local inquiry, a Welsh inquiry, is likely to bring in results far sooner.
Ruth, could I ask for your contribution? Because it seems to me that having been involved in the independent inquiry into child sexual abuse, which is split up, you might have a unique perspective on perhaps having an inquiry that looks at the four administrations, but actually comes back together to look at the overall picture, insofar as there is an overall picture to be looked at.
I think the problem with ICSA is that it is too large and has become unfocused, and thus has lost public confidence. I can also speak from a Welsh perspective, in that because it doesn't have a particular or particular days put aside for the devolved issues, it is all very Anglo-centric, and that has had an effect on those responsible for children in Wales who are not participating in the way that ICSA would have liked, because this is an English institution looking at English matters. And I think some of the Welsh authorities are going to come under scrutiny, but very much the inquiry panel, for instance, doesn't have a Welsh lawyer on it. And there you're dealing with partial devolved issues. So a lot of it is UK-wide, or England and Wales-wide, to be more accurate, but some of it is devolved, but the devolved issues are completely forgotten.
Yeah. Thank you. Any other questions or any other contributions? No? All right. Well, thank you very much, everybody, for attending. Thank you very much to the speakers, and in particular, and thank you very much, Sir Graham Hughes, for taking the time and participating in this webinar. And just about good morning, everybody. Bye-bye.